My name is Jeff Morgan. I am from Dallas, Texas. And to follow up with that last video that I did about Title 18 U.S.C. 242, the deprivation of rights, and how the dishonorable judge, Roy Graham Quisenberry in Parker County, the 415th District Court, deprived an individual intentionally, willfully, tyrannically, cruelly of his rights with his son without any reason. And the Court of Appeals, Second Appellate District Court of Texas at Fort Worth actually said, yes, he did this. It was an error. Oh, yes, it was an error, all right. It was an intentionality. And it was something that he did with full knowledge. He had been warned many times. He had been briefed many times about what he was doing. He had no jurisdiction in the matter, but he did it anyway because he's a judge. And he's going to be able to do whatever he wants to. He's a family court judge. And family court judges, you know, there's nothing you can do to hurt a family court judge. Oh, you can talk about them, but family court judges can do whatever they want to. And they know that if somebody appeals them, the appellate court's usually going to say, well, you know what, nothing really happened here. We're going to give them a pat on the back. Except this time, Graham, you got in trouble this time. You got discovered this time. And we've been court watching in Graham Quisenberry's court. I've been out there at least half a dozen times, I believe. There have been other people as well. We've had up to 12, 15 people in the court just watching the proceedings, seeing what was going on. I testified on behalf of Mr. Wright, and I'm going to read about the appeal right now too, because this is very important. Very, very important, because Rustin's case helps to set precedent for many other people throughout the state of Texas. So to go back to the Court of Appeals, the Second Appellate District Court of Texas at Fort Worth, number 02-22-00272-CV, in the interest of AWA child. This is on appeal from the 415th District Court, Parker County, Texas, trial court number CV 18-1452, and this was presented before Justices Kerr, Bassel, and Wallach, J.J. This is a memorandum opinion that was done by Justice Kerr. Now, I'm not going to read the entire thing, but I am going to read a couple portions of it. Maybe I'll come back to other parts of it later on. The memorandum opinion basically says this. R.W., the father, this was Rustin Wright. Everybody knows Rustin. A lot of people know Rustin. Rustin is a precinct chair for the Republican Party up in Collin County. Rustin has gone to legislators on multiple instances. He helped to found a couple of different groups, Americans for Parental Equality. I think he's the runner of it, the owner of it, but he has other people that help him as well. But so everybody knows that he's been fighting only to have equality in Texas, in the anti-family court. According to this memorandum opinion, R.W., the father, appeals from the trial court's final order in a suit to modify the parent-child relationship filed by A.W., this was the mother. And by the way, even though her name is A.W., I'm going to just go ahead and say it. Her name is Ashley Womack. Ashley Womack is married to Timothy Womack, I believe is his name, a former police officer. There's a lot that I could say about that, but some of the videos that I've already put out have addressed that. Ashley Womack used my name in court one time when I wasn't there, so I don't mind using her name in this video right now. So Ashley Womack, the alienator, king-size alienator, trying to present herself as an alienated mother who's suffering so badly when she has been the alienator, concerning their son A.W., and once again, his name is going by Andy. People who followed my YouTube channel probably know who I'm talking about, but in this memorandum opinion, he'll be referred to as Andy. After a jury trial, and a jury trial in which I testified, so I was there. I didn't stay in the courtroom. I was there as a witness, and I was treated like royalty. I think that at this point in time, I had done so many videos to criticize the dishonorable Judge Roy Graham Quisenberry and the court and everything else. I feel like we need to try something different. We need him on our side. Let's treat him like he's royalty. Let's give him the red carpet treatment. I mean, I almost didn't know what to do. Like, what's happening here? I was expecting to be like frisked and searched and, you know, harassed and everything else, because I had been in the past. But anyway, they treated me like I was a prince coming from exotic foreign country. So anyway, like I said, I testified in front of that. My testimony is online as well, in front of Scuzzy Steve Lawrence. After the jury trial, the trial court ordered that mother would be then the 17-year-old Andy's sole managing conservator, and that the father's possession of and access to Andy would be supervised and, quote, at times and in a manner mutually agreed to by mother and father. So the mother held the trump card. The mother had been holding the trump card for 4 years, had been doing everything that she could to keep their son from his father. And actually, I've interviewed the son, and he said, I want to live with my dad. I want to live with my dad. Well, this was just abhorrent to mother. So she did everything that she could to try to destroy that relationship. And the interesting thing is she portrayed herself as being an alienated person. And when I interviewed Andy, Andy said, no, that's not what happened. And Andy gave me details about what actually happened. This was something that she brought upon herself. In the first of these 6 issues, which is dispositive, Father argues that the trial court erred by denying his motion to dismiss the case for lack of jurisdiction. Now, before I talk a little bit further into this, I want to read what the 6 issues that the father had that he was appealing before this appellate court. In 6 issues, the father argues that we should reverse the trial court's final modification order because, number 1, the trial court erred by denying father's motion to dismiss for lack of jurisdiction. That was the issue that was dispositive here. In other words, none of these other issues even needed to be looked at because this first issue was just blatant. It was true. The court had no jurisdiction. But nevertheless, there were also 4 or 5 other issues. The trial court denied the father the right to properly present his case to the jury in 9 different ways. And I heard about some of these. I don't know about what all 9 different ways are, but in the interest of brevity, we do not set forth these ways. Number 3, the trial court abused its discretion by denying father's continuance motion based on Andy's unavailability to testify at trial. See, Andy had been sent to a school up in Nebraska, and he was up at the school, good school, everything like that, but he wanted to actually be in school in Collin County and be living with his father. But mommy didn't want this. No. So she's going to send him out of state. And then when he wanted his son to testify, no, he can't. He's unable to testify. So he said, wait a minute. His testimony is important. And the reason that I interviewed Andy is because his voice was not being heard. The dishonorable judge, Roy Graham Quisenberry III, would not give him a voice. And I was interviewing him simply to give him a voice. There was actually a time that Judge Roy Graham Quisenberry interviewed Andy in chambers, but he will not give that transcript to the father because somehow this dishonorable judge, he knows better than anybody, and he doesn't have to listen to you peons out there. He's a judge. Well, guess what? Judge Roy Graham Quisenberry, as I've said, as far as I'm concerned, you've violated, you've deprived Mr. Wright and his son of their rights under the color of law, especially due to the fact that you were acting like a judge and you had no jurisdiction. Number 4, the trial court abused its discretion by excluding the father's experts. And this is another big issue because the father had 2 expert witnesses that were going to refute the testimony of the mom. And the judge said, no, we're not going to have them. I think both of them were doctors. At least one was a doctor. The second one may have been a doctor, but knew very well what was going on in the issue. Had actually examined documents. They were expert witnesses, but the judge did not want them to testify. Number 5, the trial court abused its discretion by making the father's possession of an access to Andy dependent upon mother's agreement. Mommy can say, well, I don't want him to see you. And that's the end of that. So mommy's agreement, because of the evidence, was insufficient to establish extreme circumstances. There was nothing that was wrong going on here. In fact, once again, it was at Andy's request that I went up and interviewed him. He said, I want to live with my dad. But mommy did not want that. So she decided that they were able to put something in that says only mommy has to agree to let daddy see their son. And number 6, the presiding judge of the 8th Administrative Judicial Region abused his discretion by denying father's motion to recuse a trial court judge. And this also happened. This was the Honorable David L. Evans. I was there in that case as well. We were sitting, and it was in Fort Worth. And yes, I do believe that he abused his discretion as well. Judge Graham Quisenberry should have been recused. There were multiple things that he did that I saw in person as well as read later on in different transcripts that showed that he was not an impartial judge. He was partial toward the mom. It appeared that he was in collusion with the mom's attorneys, also the amicus attorney, and others as well. So anyway, the Parker County Court's jurisdiction, this was the issue that the Court of Appeals ruled on primarily. They said, as soon as you get this issue out of the way, nothing else matters. The father's first issue is dispositive. In it, he contends that the trial court erred by denying his motion to dismiss for the lack of jurisdiction. The father contended that Parker County Court never had continuing exclusive jurisdiction over the case because Lamar County Court's September 5th, 2018 order transferring the case to Parker County was void for 3 reasons. Very important. You have to listen to these 3 reasons and the other reasons behind it. Number 1, Lamar County Court improperly transferred the court sua sponte on its own accord. Number 2, Lamar County Court transferred the case after its plenary power over the June 21st, 2018 default modification order had expired. And number 3, the transfer order was signed after the case had been removed to federal district court on August 9th, 2018, before it was remanded to state court on February the 4th, 2019. So according to the father, because Lamar County Court's transfer to Parker County was void, the Lamar County Court never lost continuing exclusive jurisdiction over the suit. And now here's where the explanation of this comes in. I'm going to read most of this right here. It says, a trial court acquires continuing exclusive jurisdiction over the parties and subject matter of an original suit affecting the parent-child relationship, also called a SAPSR, when the court enters a final order in that suit. Once acquired, a trial court with continuing exclusive jurisdiction retains jurisdiction over the parties and the subject matter, unless that jurisdiction has been transferred to another court under the transfer provisions outlined in Chapter 155 of the Texas Family Code, Texas Anti-Family Code, Texas Family Code, I guess it's its official name. An adoption suit has been filed or an emergency exists as set out in Chapter 262 of the Code. Here, Lamar County had continuing exclusive jurisdiction over the matter when it signed the 2018 default modification order. When the father removed the case to federal court on August 9, 2018, the Lamar County Court, indeed any state court, once you remove a case to the federal court, any state court was divested of jurisdiction from that date until the case was remanded. So what Mr. Wright did, he took the case that was in Lamar County, he removed it to a federal court. At that time, Lamar County can do nothing, absolutely nothing. It has no power. Any orders that it makes are void. And so what Mr. Wright did, he took it to it was a federal removal. To give more explanation about this, that a state has no power to proceed with the case which has been properly removed to federal court. There was no doubt that this case had been properly removed to the federal court. From the time the case was removed to federal court until it was remanded to state court, the state court was prohibited from taking any further action. So there was a time frame in here, from August until some other time, that the state court could do nothing. Lamar County Court could do nothing. Judge Will Baird of Lamar County Court could not issue an order, a transfer order, anything. He had to say, look, I'm not in charge of this case. It's at a federal level, but Judge Will Baird out of Lamar County also has a problem as well. He signed a transfer order that he had no authority to do. So anyway, the father had removed the case to the federal district court before the federal court remanded the case in February of 2019. So from August of 2018 to February of 2019, that's 1, 2, 3, 4, 5, 6, maybe a little bit more than 6. Half a year, Lamar County had no jurisdiction, had no ability to do anything. But Judge Will Baird out of Lamar County said, well, screw that. I'm just going to continue on as if I do have jurisdiction. And I'm going to transfer this case to Parker County. That order was void. And that's what Judge Graham Quisenberry, the dishonorable Judge Roy Graham Quisenberry III, was told. The order is void. You cannot do this. But the dishonorable Judge Roy Graham Quisenberry basically said, screw you. I'm a judge out here. I can do anything I want to. What I find very interesting is the first sentence of the next paragraph. But our analysis does not stop here. As the old TV commercials say at night, and that's not all. There's still more. A suit seeking to modify a final order in a SAPSR is a new lawsuit. See Family Code 156.004. And they have other things here. A petition to modify an existing order affecting the parent-child relationship is a new suit. So here on August the 15th, 2019, after the remand, the mother, Ashley Womack, the alienating mom, Ashley Womack, filed the modification suit giving rise to this appeal in Parker County Court. Parker County Court, which never had jurisdiction. She's filing the Parker County Court, and I watched this. I saw the Judge Roy Graham Quisenberry, dishonorable Judge Roy Graham Quisenberry, continue to show favor to the mom, to the alienator, not even looking at the evidence. and attacking the father, sometimes ruthlessly, sometimes viciously and cruelly, in my opinion, from what I saw in person. Mother filed the modification suit that actually gave rise to this appeal in the Parker County Court. So I do want to say, maybe Graham Quisenberry did something good here, because he may have been able to get away with this, except that this appeal, which was an illegal appeal, gave rise to another suit, and that's what this appeal is based on. In that suit, Mommy, Ashley Womack, sought to modify the nunc-pro-tunc judgment. And nunc-pro-tunc is when there's a stylistic problem, basically. It could be a grammatical problem. They changed that. But she tried to modify that nunc-pro-tunc judgment to correct a final judgment entered on May 16, 2018. But, and here's the real kicker, but a modification suit must be filed in the court that has continuing exclusive jurisdiction, which was Lamar County, because Lamar County illegally, voidly transferred the case to Parker County. Parker County had no jurisdiction, but Graham Quisenberry said, well, screw that. I'm going to take it if I want it. I'm a judge out here. I got all the power right here. I got the power, baby. And, well, you kind of did have the power for a time there, Graham Quisenberry, but now the appellate court is saying, maybe you were in error. And once again, I say this was an intentionality. This was a tyrannical cruelty. This was an abuse of his discretion. This was done to deprive Mr. Wright and his son Andy of their rights. And under Title 18 of the U.S. Code, Section 242, deprivation of rights under the color of law, I believe that Graham Quisenberry should be subject to imprisonment for at least 4 years, year for year, month for month, week for week, day for day, that he inflicted this cruel punishment upon the father and the son, and that he also should be divested of his assets or forced to pay Mr. Wright for all of his expenses plus restitution, and I would say at least 3 times the amount. And I would say too that probably there should be some exemplary punishments that would be inflicted upon him. And I also believe too that because he was an abusive judge, he completely abused his power, that he should be removed from his judgmentship. I believe that his retirement, his judicial retirement, should also be garnished. If the state does not want to garnish it, they should divert it to Mr. Wright and his son Andy to give them both recompense for this judgment that Mr. Quisenberry, Graham Quisenberry, the dishonorable Graham Quisenberry, ruled against them. So if a court in which a suit is filed determines that another court has continuing exclusive jurisdiction of the child, the court in which the suit is filed shall dismiss the suit without prejudice, which that didn't happen. So Ashley Womack filed in the wrong court. And once again, I do believe that there was collusion between Ashley and her attorneys and other people involved with the judge. Judge did not want to be contradicted, did not want to be corrected. Well, live with the consequences, Graham. So the Parker County Court should have dismissed the mother's modification suit without prejudice. We sustained the father's first issue. Father had 6 issues. The appellate court said, wait a minute, hold on a second here. It's in the Court of Appeals here. There's 6 different issues. Number 1 is all we need. We're not even going to look at the rest of the 5 because we don't see that that's going to give him any greater relief. This whole thing is null and void. And once again, I would say that Graham Quisenberry did not err. Graham Quisenberry intentionally did this to deprive Mr. Wright and his son Andy of their relationship with each other, of their rights. This is a guaranteed right, a fundamental right. And Graham Quisenberry thinks that he's above all of this stuff. We sustain the father's first issue, and we will vacate the trial court's judgment and dismiss the mother's suit without prejudice. So the mother can appeal if she wants to. It's not dismissed with prejudice, without prejudice. But Ashley, dear, you get to pay all your fees this time. You're not going to be able to say, I'm going to appeal, and the father's going to pay for my appeal, because that was also written in the order that Graham Cracker Quisenberry issued. If there's going to be any appeal, the father's going to pay for all of this stuff. Guess what, Ashley? It's you. It's on you. And I also believe, too, that your name should be shamed because you did this intentionally. You portrayed yourself as being an alienated mom. You were the alienator. You were the vicious person that did this. You destroyed the relationship that existed between the father and the son out of your own will. And I believe in collusion with your attorney, Scuzzy Steve Lawrence, And you also had Scum Bob for a while, Scum Bob Thornton, but you dismissed him. I don't know, maybe he wasn't willing to do everything you wanted him to do. I don't know. Zach Pettigrew, the amicus attorney, he was another one of these people. You portrayed yourself as being an expert, and that you knew better than what the experts did. You disagreed with the experts, and you knew better. And you know what? Pay up. Pay up. Regardless whether it's from Graham Cracker Quisenberry, I think, or whomever, I believe that Rustin Wright needs to be made completely full. And full is not just dollar for dollar. Once again, I would say at least 3 times the amount. I believe there should be punitive damages assessed. I believe Scuzzy Steve Lawrence, he knew what he was doing. I believe that he should be considered for disbarment before the State Bar of Texas. Amicus attorney Zach Pettigrew, I believe he should be ineligible to ever run for judge. I also believe, too, that he should be investigated by the State Bar of Texas. Ashley Womack, I think the fact that your name is going to live in infamy with what you've done, that's going to be enough for you. We addressed none of the additional issues because they afford the father no further relief. Conclusion is this: having sustained the father's dispositive first issue, we vacate the trial court's judgment and dismiss the mother's suit without prejudice. Elizabeth Kerr, Justice, delivered July the 20th, 2023. So first off, I want to say congratulations to Rustin Wright. There were a lot of people, and I have to say I was one of them, that wondered if you were ever going to see any justice. And we questioned whether you should keep on doing it because you were spending so much money. But you stuck in there. Even when many naysayers were saying, Rustin, don't do it. I'm glad you did it. And I'm glad that you had Ben Beveridge there to help you. And Ben, kudos to you. Ben Beveridge Law Firm. Ben got involved in the family law industry to protect people because he himself was being abused by the anti-family law industry, from the family destruction industry. So what he did, he's a very smart guy, intelligent, very well read, liked Ben a lot. He decided to go to law school so that he could work from the inside to fix the problems, at least to represent people so that justice would be done. Ben Beveridge, kudos to you. And I don't know what the remaining steps are going forward, but Ben, I just want to say that it was great to get to know you. Most of my friends that I have right now in the state of Texas have been because of what the family destruction industry has done, what this anti-family system has done to people. And we have decided to band together, and as one person said, we're now part of this group that terrorizes anti-family law attorneys. Seriously, we're exposing what is evil, and everybody should be exposing what is evil. We have been court watchers, and we encourage you to be court watchers. Go into the court, see what's happening. If you have a friend that goes to anti-family court, you should be there. Friends, do not let friends go to anti-family court alone. I realize you can't go to every single case that somebody's going through, but at least go to some. If you're a legislator, I believe it's incumbent upon you at least once a quarter, and perhaps even once a month. You should go to these courts and see what's happening, because the legislature is responsible for a lot of the stuff that is going on. They try to pawn off the responsibility to the State Commission on Judicial Conduct. And the State Commission on Judicial Conduct, they basically become a rubber stamp for injustice in most instances. And you might say, well, they don't have enough money, they don't have enough staff. That may all be the case. They are also restricting the way that the public can now contact them. You used to be able to submit forms online because they were really concerned, and all of a sudden now they had people submitting forms online and stuff like that. And they said, whoa, we're getting overwhelmed with work. Now you have to actually mail it to them. I believe that based on that alone, that the State Commission on Judicial Conduct is not interested in actually solving the problems of judicial misconduct. There are numerous issues we could talk about, but our legislature needs to fix some stuff. Our judges need to fix some stuff. We do have some attorneys that are actually starting to speak against the practices that are taking place in these courts, in these abusive anti-family courts. They're talking about what's taking place among their colleagues, whether they're friends or enemies or whatever, things that take place where people are deprived of access to their children, deprived of hundreds of thousands of dollars in some instances, and judges don't care. They're going to say, well, we have immunity. Anytime you challenge us, we have immunity. Well, Judge Roy Graham Quisenberry III, you don't have immunity under Title 18 U.S.C. Section 242, deprivation of rights under the color of law. You operated as a judge when you had no jurisdiction. You were operating as an official with no jurisdiction. I believe that you should be subject to this penalty, and I believe at a very minimum, you should be looking at 4 years imprisonment and against full restitution and at least 3 times the amount of what it cost Mr. Wright, as well as recompense to Andy and punitive damages as well. Your type of behavior was abhorrible. You threatened me. Your bailiff threatened me. Other things took place. I know that there was collusion. I believe that you were involved with jury tampering in this case that was appealed, because there were several people that said Judge Graham Quisenberry went in and talked to the jury, tried to tamper with the jury. That's jury tampering. And I believe that should be investigated as well. Judge Roy Graham Quisenberry, I believe from the reports that I heard, I did not witness personally, from the reports that I heard, was also engaged in jury tampering. So all of these things, I believe that Judge Roy Graham Quisenberry should be imprisoned, should also be made to pay, recompense Mr. Wright for his pain and suffering and all of his expenses, and also give restitution to his son Andy as well. Thank you.